arrest of Mahmoud Khalil and President Trump's decision to go against a federal judge's order, at least on the surface, to halt deportation flights are raising questions about the administration's legal boundaries and constitutional rights in general. So joining us now for some insight into what's allowed and what this all means going forward are two legal experts, David Melton, a retired attorney who's also part of the Chicago Council of Lawyers, and Jason Mazzone, a law professor and constitutional law expert at the University of Illinois, Urbana-Champaign. So let's start with this battle between the Trump administration and a federal judge over deportation flights. The judge wants the DOJ to prove it didn't defy his order to halt the flights. David, does the Trump administration have a case here for going against the judge's order?
No, they not only do not have a case for ignoring the judge's order, but they don't have a legal basis for deporting these people insofar as they're relying on the 1798 Alien Act, because that act only applies in wartime. And as far as I'm aware, Congress has not declared war in Venezuela.
Okay, Professor, typically if a judge makes a ruling, asks for something, that order is expected to be followed. Of course, I don't have to tell either of you this, but it's all part of the critical check and balance between the three branches of government. So what should the consequences be when that doesn't happen, or if the Trump administration repeatedly defies judicial orders?
So we might want to say at the outset that the judge in the case, Judge Boasberg, has not determined yet whether there's been any violation of his earlier order. Right. So that's still to come. The judge, I think, is very much on top of the case. The lawyers are there in court. He's demanding responses from them. He's gathering the evidence, and he will make a determination as to whether there was a failure to comply with his order. And if so, what the circumstances were, who was involved. Was it the president? Was it somebody else? And whether there are any consequences that should attach. Federal judges have a variety of tools to address contempt of court or the failure to comply with an order. I should say, though, that ultimately, and I think this goes to your introduction to this issue, ultimately, our system very much depends upon voluntary compliance, especially when the government is a party with the decisions of the courts. Now, of course, they can be appealed, and I assume they will be appealed, perhaps all the way to the Supreme Court. But our system, at the end of the day, is one in which judges don't have armies, they don't have the power of the purse, and so compliance with, acceptance of court orders is a really important aspect of our judicial system.
David, your thoughts on calls for the impeachment of any judge who rules against President Trump's wishes?
My thoughts are that those are frivolous actions that have no basis either in law or in policy, and that the people who are proposing that should be held to account politically for those kinds of improper actions. Impeachment requires conviction of a judge for high crimes and misdemeanors, and that's not going to happen in the current Senate, and there is no basis for those kinds of charges in this case. And these trying to impeach someone for policy differences that they may have with a judge or legal differences that they may have with him is undermines our system and is completely improper.
Professor, you brought up voluntary compliance. I really want to quickly, because then I want to ask you one more question before we go, and we're running out of time. I mean, what if, let's just say what if, things keep moving forward and there is not voluntary compliance? I mean, you talked about some courses of action, but what happens if they just continue or they begin, I guess, to defy orders? Would it take sort of what would happen then?
Well, one of the key aspects of our constitutional system is it's very hard for any individual, however ambitious, however popular, to control all of the parts of the government. And so that sort of division of power to Congress, to the states, and also the role of the general public, from whom all government emanates. Those are important checks. It's really not in the interest, and I think the president would understand this, not in the political interest of the president to alienate the judiciary. We have a Supreme Court with a majority that I think is inclined to be sympathetic to many of the big things that the president would like to do. And I think the president fully understands that you don't want to make the Supreme Court mad at you when you're undertaking all of these programs. So I think that also is a significant check on just how far things might go. But as I said, we're in early stages of the case. The judge is a very skilled judge, very much on top of this. The system does seem to be working in the way it was designed.
So far, okay. And then really quickly, Professor, and I'm so sorry that to David and you, Professor, that we have to be so quick, but that's the nature of television. Let's talk about real quickly Mahmoud Khalil. Being able to protest almost always, not always, but almost always is protected by the First Amendment. Do you believe, Professor, that his First Amendment rights were violated, considering his arrest by ICE and the ongoing case in that regard?
There's a very important distinction here. Certainly, non-citizens in the country have First Amendment rights, robust First Amendment rights. That means that the government, for example, could not prosecute, lock up somebody because the person is criticizing the government. But when it comes to admission into the country or removal from the country, the normal rules just don't apply under Supreme Court doctrine. The government has very broad leeway to refuse to admit somebody, to exclude a non-citizen from the country, to remove a non-citizen from the country. The Supreme Court might take a different view of that issue in the future, but we just don't have a system in which the same strong First Amendment protections apply on that particular issue. And the main reason is that courts don't consider deportation or refusal to admit as a punishment in the same way as a fine or a period of incarceration.
Okay, David, real quick, yes or no, though, is his arrest setting a dangerous precedent, possibly? And I'm sorry, it has to be yes or no.
It does set a dangerous precedent, and it is not true that permanent residents have significantly different First Amendment rights than citizens. In fact, the statute in question that the administration was relying on, they overlooked an exception that expressly states this. Section 212A3C3 says that people may not be deported for expressing their beliefs or their associations, if doing so would be legal in the United States, which is clearly the case with Mr. Khalil. And so the statute they were relying on has no application.
Those are statutory protections. They are not First Amendment protections. It's a very important distinction.
There's a lot.
That's true. They are statutory, but I believe that if the Supreme Court had to answer that issue, they would say that permanent residents also had the same First Amendment constitutional rights, whether it's by statute or by constitution.
Two very interesting points both of you are making. There's a lot to unpack. I know there's a lot we can continue to discuss, but I think it's really important that we're at least discussing it now, even if it's in a condensed version. So David Melton, Professor Jason Mazzone, thank you so much for joining me this morning. And now we have